Well, we've got about 13 participants right now. So I'll begin with a brief introduction. Good afternoon and welcome to our Project Management Roundtable. Today, Mike Herlihy from Ames and Gough will give us a presentation on the control of risk. Mike has over 44 years of insurance experience, and we are very lucky to have him here with us today. Mike, again, thank you for being here. And could you perhaps begin by introducing yourself a little bit, and then we can proceed with the presentation.
Sure. Thank you, Tracy. I'm a equity partner and executive vice president at the brokerage firm of Ames and Gough, based in Washington, D.C., with a significant office in Quincy, Massachusetts, where I'm located. I've been with Ames and Gough now for 22 years, and I've had 22 years of experience on the underwriting side, all with design professional liability insurance. So I've had an extensive background, primarily with really the major firms in the country and even in the world, the Bechtels, the Ralph M. Parsons companies, people like that. That's the business that I underwrote when I was at Lexington Insurance Company before joining Ames and Gough. So I've seen it all: central artery claims, Deer Island wastewater treatment claims. So the presentation we're talking about today is really designed to focus on the steps that can be employed at the outset of a project and during the course of the project to really keep the incidence and severity of claims down. A lot of it comes to, interaction with everybody in an appropriate manner and dealing with the risks that you see out there and making sure you've got a plan in place to make sure that what you release isn't going to have any significant errors or omissions in it that could lead to potential for claims. So let's see here. We're going to be talking about the general business risk management steps. These are general steps that every business has to consider when you're considering risk. We're going to look at project risks that are specific to design professionals, touch on what those are and the areas where we could see problems. And then we're going to talk specifically about the techniques to control those risks and discuss examples of risk management techniques. And what I'm going to then do is the end of the session has a quiz, if you will. So we'll read the slides and then I'll ask anybody who wants to answer it and explain your reason why. So hopefully we'll be able to, do that on a remote basis like this. The simple risk management steps that everyone implores when they, take on something, whether it's a project risk or any other type of business risk, is you identify what the risk is initially, and you analyze how severe is it going to be if you don't deal with it. Some risks can be very minor, others major. So you analyze that risk and then evaluate it as far as what would I have to do in order to make sure I don't have a problem associated with this particular risk. And then when you've come to that evaluation, you put your plan in place. This is how I'm going to manage it. And the final step, of course, is to monitor the results. Am I getting what I hope to achieve after I evaluated this risk and came up with a risk management step? Am I actually succeeding at this, or do I need to make any changes on the fly? Project types. The project risk identification in the insurance industry, these tend to be some risks that have high frequency and high severity for various reasons. Residential multifamily work for developers, the risk here has to do with the fact that oftentimes a developer is not the end user anyways. You're selling units to another party after the fact who ultimately would be the source of a claim. And so you have to manage the risk associated with a developer who might be more focused on cost, getting that project to look good, selling it, but maybe on the other end, you've got homeowners that buy that condo or house or whatever it might be, thinking they were getting some really, really high quality materials, and then not being happy if even the smallest thing breaks. So that has produced probably the most frequent and severe losses in the insurance industry, at least as long as I've been around doing this type of business, particularly against architects. Municipal buildings and schools, the main dynamic there is oftentimes you are dealing with public agency people who either run for office or, school committee, things of that nature, who, don't have a background in construction, don't necessarily understand construction. And a lot of the process involves you being able to educate them so they can see that you're working in their best interests, and they have the right expectations with respects to the project. That has been mitigated somewhat in Massachusetts over the years because of the agency that oversees school construction. And that has been really a help in Massachusetts, because in the early 2000s, things were not going well with school construction in this state. Streets and roads, there it's an issue associated with the need to, divert traffic while an engineer is working on the road, contractors are working on the road, and that tends to lead to accidents and injuries and lawsuits associated with those, traffic patterns and things of that nature. Parks and recreation facilities, the risk there is usually a severe one. We've had some clients that have dealt with parks and have faced injuries by children at those parks. And the one thing that we all tend to know about in the insurance industry and the legal industry is if you have an injured child, you probably don't want to put that in front of a jury. So you're more inclined to settle. And as a result, you're paying out claims that maybe you could conceivably not be responsible for, but you don't want to take the risk of going to court to try to prove that and just having a sympathetic jury tell you otherwise. Manufacturing facilities, including process design, the big risk there is a lot of moving parts, really and simply. If the process doesn't go as you designed it to go when you're doing the commissioning stage and you discover a lot of problems with it, you could be shutting down a facility, doing a lot of rework, and all during that period of time, the manufacturer is not getting the benefit of a product that's out in the marketplace that they're making money on. So once again, the consequential losses could be significant associated with that. So these are just some examples of project types that create high hazard. Project characteristics are also areas of risk that need to be effectively managed. Probably the most important one is the adequate scope, site, and budget and schedule. I mean, we talk about over the years different project methodologies such as design build and fast track and things of that nature. All of it's associated with an attempt to try to get the cost down with regards to the project, but you can only push something so far. Ultimately, there's a cost associated with everything we do. And the question becomes, for the project that you're getting involved in, is there really an adequate budget in particular? Is the schedule good? Is there a good scope that's really fleshed out so we don't run into problems and we don't have an unhappy client who's thinking he's paying too much for the project he's embarked on? Is there agreement on all key components? Again, this comes down to whether or not everyone's on the same page, contractor, design team, and owner, as far as what's going into this project, how it's going to be done, the steps, and so forth. In a public sector, is there any public opposition? Because if there is, that obviously has to be managed at the outset. Get people on your side, not have them opposing the project. And we've seen some recent developments in some of the local municipalities near the Boston area where there's been opposition to new residential developments and things of that nature that have delayed the projects while these things get sort of scoped out. And we've had engineering firms sued by various parties alleging that that the work they did on these projects was not done properly, things of that nature. And now we have to stop the work and prove that that's not the case. We got the right permits and so forth. Any unusual regulatory requirements, how that might affect the project, things like ADA. Do you have to design in accordance with certain standards that have to be met? As I mentioned, the project types with the high incidence of litigation, the residential being probably the top of that list. And then project delivery, as I said at the outset, we're always looking for more improved ways to deliver the project, but the focus can't just be on cost. It has to be on something that really effectively works, or as we'll discover down the road, for example, like fast track, the normal steps with the design process is a sequence. And oftentimes with fast track, you get out of the sequence. You're doing parts of the design and then bringing it back in rather than doing a step-by-step approach. And that can lead to some issues if it's not properly done and properly controlled, and there isn't a double check on what may have been done out of sequence and now is being added to the project. Client nature. This is really what it all comes down to here is, do you have a fair and reasonable client that you're working with? We talk about it in all businesses, you always hear that concept. Sometimes it would be good for you to fire a client that just isn't the right fit for you. We're always afraid to do that sort of thing. But, getting involved with a new client, we should be doing some investigation as far as what this client understands about construction and how are they in general, do they treat construction and contractors and engineers and architects? Because if they're not going to be fair, as good as you do, you could find yourself in a major problem with a client that's like that. So do they have a realistic expectation of what will be involved? If there's been past projects, have there been litigation on those past projects? Why has there been litigation if there has been? Do they have the sufficient resources and the capital to build the project? Are they pushing the envelope here? Or do they really have a good, adequate contingency set aside for the things that no one could possibly anticipate at the outset? The most important thing is, does the client treat designers fairly? There's public agency work we've seen over the years, and even in the private sector. When I look at contracts, I oftentimes see contracts, and those are an indication to me as far as whether the client's being fair and reasonable. When I see contracts that are trying to shift the vast majority of the risk onto your shoulders, even things you cannot control by way of that contract, I know I've got a challenge ahead of me. I got a client that is looking to get away with something in a way, not willing to take the risk associated with the construction, just thinking if the slightest thing goes wrong, they may be looking in your direction. So contracts oftentimes, and how they're written and how fair are they, can be a good indication of whether the client's treating you fairly or not. Does the client understand the extent and scope of your services? For example, we've had situations over the years where we see a client agreement that may be looking for you to share responsibility with the contractor for things like site safety. They don't understand what the extent of your services are if they're looking for something like that, but we've seen it. Your background and experience, most important has always been that within your firms, you've got people with different levels of experience and skill and background. And it's always good to have a team put together where you've got senior people, but also, maybe less senior people working on the team, but not simply delegating a particular job or project onto a new staff because you're not getting the fees that you otherwise would get. You want to have the right oversight. You want to be sure that the knowledge your firm possesses is being communicated across the spectrum, because what you're trying to do here is deliver the best possible result. And the only way you can effectively do that is if you are paying attention to having knowledgeable, skilled professionals doing the work and having the right peer reviews and quality control procedures in place. It's important that there's full knowledge of all important project variables. and supplementing your team when you don't have the services in-house, structural, mechanical, et cetera. Supplement your team with qualified sub-consultants. A step that sometimes firms miss, particularly with sub-consultants, is they think, okay, I've hired a really great firm to do the work here for the mechanical engineering piece. And you don't feel like you might have to do a lot of oversight because this is a qualified firm and you've seen them perform well in the past. But oversight's necessary regardless of what firm you're hiring. And you really have to treat them as part of the team as almost as if they were your own employees, making sure that they buy into your quality control program, making sure they have the right procedures in place at the outset, and that there's proper checking being done so you don't have to worry about it. But you simply can't sign them up and then hope that when they show up when they have to and do the work that they have to, and you're not paying attention to those details. They got to be treated as team members, which you sit down at the table and review their work and make sure everyone's all on the same page. General risks that you face, construction industry factors. We're seeing that right now with inflation and rising interest rates, but also supply chain problems that could delay projects. And what we want to be sure of is, we again come up with a schedule that might reflect some of that, or that the owners are aware that this could take place. So there may be delays and they're not getting angry looking at you and thinking that you didn't give them a proper expectation as far as how long this project might take. Project as constraints, delays in materials, scheduling of subcontractors, tight budgets, weather and site conditions obviously is pretty important in the New England states. Though it seems over the years that, we've become more effective at being able to manage the weather to a great degree. So we can do a lot of work even in the winter that in the past, perhaps we couldn't. So with regards to the general risk management steps, what you're doing on your end is you're deciding with every risk, do I retain it? Do I avoid it? Do I allocate it to someone else? Do I transfer it? A good example of a transfer mechanism might be you transfer to insurance claims that your firm can't afford to pay. And risk mitigation is a key quality component here that I don't want to overlook, and probably one of the most important ones, because we all would prefer that we don't have to deal with a loss arising out of risk in the first place. So what can we do in the front end to mitigate the risk? A thing I've preached over the years that I've been doing these sessions is in red here, and you will have access to these slides after this presentation. You feel free to refer to them, and if you need to and got any questions, you can feel free to drop me a line. I'm happy to answer. The party in the greatest control of a risk should retain and bear responsibility for that risk. If you keep that in your mind when you're sitting and considering risks that are being transferred by contracts, risks that you think you're going to take on during the course of the work that you're going to do in this project, the first question you always ask yourself is, am I the person that's in the greatest control of this risk? Because if I am, then I can manage it. If I'm not, then I've got to look at another way to effectively manage this risk. And this all comes down to pre-project planning. I mean, I think we've gone through pre-project planning meetings over the years. The general things we know come up in those meetings, such as schedules for shop drawing reviews and things like that, schedules for when the deliverables will be made, and that sort of thing with respects to the design. But, there are occasions when people want to get going and they got a short window and they try to maybe skip steps, but pre-project planning is really essential on every single project, regardless of its size and scope. It may take less planning on a smaller project, but it really has to happen. You just can't dash right into it. Contracts delegate risks to each party, and that contract needs to reflect what I show here in red, that when you're delegating a risk to a party, they're in the best control of that risk. Simple things like site safety, obviously the contract is in most control of the site, so therefore they should be delegated site safety risk. The architect should not. Design risk, the initial design should be a risk that you bear and should be delegated by contract. But it's important that contracts reflect an appropriate delegation of risk, because when they don't, and there's many occasions when they don't, that's when we see some really significant claims that we probably shouldn't have been involved in to begin with. But before accepting the risk, decide if you can truly control it and control its cost and liability. So you're retaining your responsibility for errors and omissions in design. You retain responsibility for any firm and any individual that you hire and working under your direction. Shop drawings, responsible for verification of design intent, but you're not responsible for dimensions and calculations. And simple steps we always point out with regards to shop drawings is always make sure the contractor stamps it before they send it to you. Even if you believe the contractor didn't even look at it and they had their, office manager simply stamp it and send it out to you. If you see something obvious, send it back to them to correct it. Even if you know how to correct it, you don't correct it, because when you take on those kinds of roles outside of the contract, you give an outside party at the time of a claim a reason to make you responsible for what might have gone wrong based upon how you performed in the job. So you stick within your contractual scope of duties. And when it's someone else's duty to fix it, you tell them to fix it. You don't tell them how to fix it. You then ask them to resubmit it to you for approval. The general rule of thumb that we see consistently, especially with design, bid, build, is your role when you're at a site, whether it's, to do it should be observation, and it should be to confirm compliance with design. You're not responsible for the quality construction. And I know AIA agreements over the years have used the words endeavor to guard against defects. And I think they're trying to improve that language and change that language over time, because yeah, you can endeavor to guard against defects, but we don't want to give the impression that that's what your role is out at the site. You're not out there to check on the quality of the construction. You're more out there in terms of determining that it's in compliance with design intent, and probably also to confirm that it's reached a certain level of construction so that funds can now be released to the contractor for the payment schedule. But that's an area that we've always worried about, because once again, if your employees are out at the site and they start doing things outside of the scope of their duties on the project that go beyond simple compliance with design intent, if they start doing that, you open the door for them to be now responsible for things that they shouldn't be. So with risk avoidance, we always want to make sure contracts are pretty clear in this regard. And I've just completed a safety session with a couple of engineering firms, wherein we talked about a couple of situations where the firm was acting in a construction management capacity, and the owner was asking that they verify that the contractor had a program in place and for safety in particular. And we needed to be sure the contract itself was pretty clear that even though I was verifying that they had a plan in place and that they were following it, I didn't have responsibility for the ways, means, and methods, and further reinforce it by saying we had no responsibility for site safety other than to verify there was a safety plan. So we had to get really, really down in the weeds on the contracts and actually coordinated the engineering agreement with the contractor agreement to reinforce that this was the contractor's duty, so that we wouldn't have somebody say, well, I see in your contract, you had to verify there was site safety. So didn't you take on a companion duty with the contractor? we wanted to be sure we avoided that because we didn't have any control over the work and we couldn't stop the work if we saw something unsafe. No responsibility to be sure contract is paid what is due. It's simply a situation when you get involved with certifying for payment, it's more that here's the schedule on which the contractor is to be paid. And I went out to the site and I saw they've reached this level of completion. So based on that, it would now be appropriate for the owner to release the funds. But you're not responsible to make sure that the owner actually releases the funds. That's on him. Again, this concept of being careful about shop drawing reviews and not doing something that might give you overall responsibility for everything in that shop drawing, even though it can be a challenging process, sending something back when it might be something you could easily fix. You have to do it just so you're not giving an outside party at the time of a claim the opinion or belief that you really had overall responsibility just by the way you behaved. No guarantees or warranties of any sort. Every professional liability insurance policy out there, the first exclusion they all put in them is the you're not insured for express warranties or guarantees. And that's simply because you can't be perfect. So how can you guarantee or warranty professional services? It's not like a product manufacturer. You don't get the chance to do it over and over and improve your product. No, you got one shot to get it right. And as a result of that, you're not expected to give warranties or guarantees. But if you give them in a contract, you're going to be responsible for them. And worse, you're not going to have insurance for them. And certainly the most important thing we always focus on is don't get into shared responsibilities with the contractor for construction. Make sure that you keep the contracts separate and keep the duties separate, because we don't want you held accountable for everything that goes on at the project, including construction defects. Risk allocation transfer. I want to point out this one in red. Treat the contract as an important deliverable. And I thought about this the other day because I had a situation involving a firm in another state. I won't identify the state, but they were working with a public agency and it was a city. And the city actually took out and had a separate page that they had to sign. And they identified this page as insurance requirements. Well, the page was nothing to do with insurance requirements. It was the indemnification agreement. And this was an RFP. And I got a copy of what they were being asked to sign. And I was asked to comment on it. Were we okay on this? And it was a business development person that had sent it to me. And this basically said that the engineering firm that was involved in this case was going to be responsible for everything, any and all claims of any nature from wherever they may have come, unless they were due to the sole responsibility of the city. And this page had to be signed and dated. And the firm was sending this to me. And I went back to the principal I normally go to say, I don't even know where to begin with this. I'd like to speak with you because I'd like to talk to you about the breadth of what they're asking for beyond even just insurance issues. This thing is beyond what you can even basically control. Turns out the principal was out sick. And so when I sent that note back over there, one of the people that was on the email as a carbon copy said, oh, well, you know, he's out sick, but I also wanted to pass this along to you. And what they passed along to me after the fact was a list of questions. That there was a question and answer period, as this was a formal RFP process. And right there in the list of questions, a number of engineering firms that were bidding on this job all questioned this indemnification agreement. And what was happening was my firm wanted me to, I guess, bless this thing, not touch it, because the response that the city gave back to the other engineers that asked about this indemnification was, we'll take that under consideration, but note that that if you want to make changes to our indemnification, we have to consider that in who we select for the job. So my firm was kind of hoping, rolling the dice, and maybe Mike could say it's okay to do when they knew everybody else was already objecting to it. And I guess my point is, if you treat that contract as an important deliverable and you look at an unfair indemnification agreement, you certainly would not take a job for $2 million of fees when you know it's going to cost you $4 million. The same thing with some of these contracts. You don't want to be taking on terms and conditions that you hope will never come into play when you know you can't handle them as a firm, because if they do come into play, then what do you do? So, that should be treated as an important deliverable, not just as something that needs to get signed so we can move ahead with the work. Allocation of design risk to the designer. And again, construction goes to the contractor. It's simple. That's what we are capable of doing. That's what we're in control of. So we take on what we can control, and the other guy takes on what they can control, and that's where we're at. Allocation and funding and payment risks stay with the owner. You don't want to be somehow brought into a situation where they're claiming that you didn't properly certify something, and that's why payment wasn't made by the owner. So we want to be clear, the contracts are set up in such a way that you certify based on what you're seeing out there. The real payment responsibilities stay with the owner and they're not yours. Review in detail any contract before signing. We're a specialist broker. Pretty much most of the brokers that provide insurance to design professionals will all review contracts at the very least to tell you whether you're insured for it or not. And there are qualified law firms out there that can certainly give you advice on these contracts. Please use us. It's important, because something that you think is very simply stated might have a legal ramification that we're not aware of. Lawyers pick this stuff up because something I learned in Massachusetts. If I say I'm responsible for any claim caused by my services, just the simple word "caused by" is apparently broad enough in legal interpretation in Massachusetts to mean anything related to what I do. So you have to change "caused by" to the extent caused by in Massachusetts, or otherwise you're taking on a broader risk in the contract than you won't on the outset that you realize. I didn't know that, but a lawyer pointed that out to me. So sometimes what you think and I think is a simple English language has a different meaning when it comes to a court of law. So contractual risk allocation, the things we look very closely at, and scope of services, making sure they're specific, they're not open-ended, they don't say anything and everything implied or expressed, because that leaves it open-ended. And the risk is if that scope of services is not pinned down, you could find yourself in a disagreement with an owner that you're paid a certain fee, but that owner's thinking you're doing more work than you thought you were going to do because of the words expressed and implied, that they go beyond what the specific scope was that you thought at the outset you were going to be doing, and for which you put together your charge as far as here's what I need for a fee in order to do this list of scope of services. So you don't want it left open-ended so it opens the door for them to be getting something out of you they didn't compensate you for, and now you're watching your profit get dried up. Payment clauses. One thing we see in payment clauses that we're always concerned about is we don't like the owner to say, I'm going to set aside money. If I see what I think is an error or omission or a problem, I'm going to set aside an appropriate amount of money to compensate me to fix that problem that you might have caused. We don't want to see those in payment clauses, because if the owner uses that and you don't agree with it, there isn't a problem with your design. He's really holding back money that he should be paying you. What are you going to do about it? You're going to have to sue him. And so you're the one bringing the claim, and you're the one that has to hire the lawyer to bring the claim, and you're not covered by insurance for that, unless the owner kicks back and says, I'm now holding you responsible for this error or omission. you're really filing a payment action is what you're doing if they do that holdback. And so you don't want to be in that position and spending the legal money to do that. And also, if the owner really has a problem with your services, a holdback of your fee is not the right action. It's basically take it as a dispute and treat it as a dispute and have a disputes resolution clause in the contract to deal with something like that. Standard of care provision, most of the time, we don't have any problem with these. People understand what the standard of care should be, but on occasion you see people pushing for best, first class, highest, and there's ways we can manage that. I mean, when you talk to people about that, they say, well, look, I didn't hire you because you're going to be ordinary. So we don't want you to be performing as ordinarily as any other firm would perform. We selected you because we thought you gave us the best deal and you promoted yourself as being able to do that. Well, we could compare you to a highly qualified specialist firm practicing in the United States. We could compare you to that standard. So we could take and elevate the standard accordingly, just as long as it can be compared to another design professional, so that we are not guaranteeing your work, but instead we're holding you to a standard that someone can recognize and that the insurance companies can cover you for. So again, we can change words like highest, first class, that sort of thing, to be, I'll be compared to the services normally performed by nationally recognized specialist architects performing similar projects. The clause we change by far the most is the indemnification and hold harmless agreements. And they have to be very careful that when you give someone an indemnification, it's to the extent of the loss that you cause. And we don't agree to defend them because they cannot be added to a professional liability insurance policy as an additional insured. So if you agree to defend the owner, you have to do that. The professional liability insurer will not pay you back for it. The professional liability insurer only agrees to defend a party that is an insured, a named insured, additional insured on the policy, nobody else. And we cannot get owners added to any professional liability policy as an additional insured, because that would change the standard of care. Those policies were designed to cover design professionals and design professional standard of care. If you add the owner's standard of care is strict liability. They get the best benefit for the project, and therefore our court system holds them strictly responsible for their project. So if you put them on as an additional insured, the insurance company would be stuck with now having to give coverage for strict liability of the owner, which none of them will ever agree to do. That's why they can't be added. Limitation of liability, those can be used when it's appropriate. Sometimes you get a very small study or something like that, that's the contract. And you don't want to take on massive liability over a small study for which you got a small fee. So that may be a time when you come in and say, well, can we limit our liability to our fee or $50,000, whichever is greater. So those can be used. We don't often see them get them in the contract. But the one warning I'll give you about limitation of liability is don't ever accept them from a sub. Do not ever hire a sub-consultant and agree to the sub-consultant's contract, and in that contract is the limitation of liability. Because if you do that, the liability falls on your shoulders for what the sub causes. So if the sub limits their liability to $50,000 and they cause $1 million loss on the project, it's your insurance that's going to be paying most of that loss. So you cannot agree to give any sub-consultant, regardless of the type, a limitation of liability unless the owner is willing to give you the same limitation of liability. Factors in accepting risk. Again, the legal system and expectation of designers, we know what that is. We try to keep ourselves within that scope, and that's where the risk we'll accept of those. Make sure you can control and manage it. If someone's in a better position to control and manage it, then they should be delegated it, not you. Liability risks, are you insured for them under your insurance program? And that's, again, you can go to us as brokers, your own brokers. They can advise you, okay, in this contract, yeah, we know the liability risks you're taking on, and yes, you're insured for them, or no, here's where the gaps are and here's what we need to change. Courts rule you can't be perfect. Standard of care is, again, based upon the fact that each project's different and unique. So all you can do is render your best professional judgment, and you can't be perfect. So the courts don't expect you to be. And there's been numerous instances over time where design professionals have committed significant errors and omissions and caused problems at the project, but they could demonstrate that every other engineer faced with the same set of circumstances, or every other architect faced with the same set of circumstances, would have committed the same errors or omissions, and therefore courts have literally not held them responsible. Transfer. Transfer is done through contract. The owner transfers liability to you in a prime agreement. You transfer liability to your subs in the sub agreement. But recognize insurance is also a risk transfer mechanism. The liability risks that are beyond your financial capabilities, that's why you buy insurance. That's why all businesses buy insurance. So, but the insurance policy is a contract with the insurer. The insurer agrees to take the risk from you, but recognize an insurance policy is a contract. The insurance companies do not insure any of your contracts with your clients. Their contract is between you and them, and their policy dictates what they'll cover and what they won't cover. So you can't just take on any liability in a contract and think your insurance company's covering it. No, it's always subject to their policy. Mitigation techniques, just having a quality control program in place at the outset, internal and external peer reviews, following design checklists that remind you of the steps you need to take to make sure you don't miss something. Partnering has been a tool used over time too, where you get input from contractors, that can help you perhaps understand better the best way to do your designs. Having control procedures for shop drawings and other submittals like RFIs, so they're dealt with in a timely manner, and making sure you're hiring proper subs and using them in an appropriate manner where they're all tied into your quality assurance, quality control program. The pre-project planning I mentioned at the outset, but there should probably be something that's done on every project. I won't go into details on this slide because I'd like to get to the question and answer session. But pre-project planning is essential and important. You need to be sure everybody understands what we're doing here. And the only way to do that is to sit at a table and say, okay, this is what we're attempting to do. Here's the steps that we're going to need to undertake. And, here's our roles and responsibilities, who's going to be doing what as we flesh this whole thing out. Mitigating contract risks. This is a good slide to refer back to when you're looking at a contract. Accept the risks over which you have control. Scope of services, make them specific. Indemnification must have no defense obligation. Indemnification of others must be limited to the harm caused by your actions. Standard of care cannot include warranties and guarantees. Act reasonably and prudent. And if services change, get a written amendment to the contract so you now have a contract that applies to those new services and it's not left open-ended. Make sure your subconsultant agreements flow down appropriately to the sub, the liability you're accepting in the prime agreement. So let's take a look at some of the questions here and see what you think. We have a design professional tells an owner in the meeting that they stand behind their work. They will be responsible for any damage that they cause in the performance of design. Is this risk allocation, risk acceptance, or risk transfer? Anyone?
We had somebody put in the chat a couple people said risk acceptance.
That's correct. You're accepting the risk over which you have control, and this particular step is risk acceptance. I don't see the chat on my screen, probably because I'm screen sharing, so I might need you to just do that for me, Tracy, going forward. A structural designer notices that the geotechnical engineer's report states that the soil conditions at the site have a heavy concentration of sand. Is this risk identification, risk mitigation, or risk assessment? Anything in the chat?
Yes, we had a couple people say assessment, identification.
Well, there it is. Let's see. This would be identification. You might be, the next step to this thing would be assessment and then mitigation. But really what we know here is that the conditions are identified as having a heavy concentration of sand. So that tells us we have to do something about the project to deal with that as we design it to support the site. So, you know, so we know we've got the heavy concentration of sand that's identified, but at this point we haven't assessed it as far as what we're going to need to do to control it, and we haven't really mitigated it either. Let's see, go back. The architect entered into a written agreement warranting that the design would meet specific criteria and the owner would bear no added costs beyond the budget to achieve the promised result. Architect responsible for all added costs. This is a good example of fair allocation of risk because the risk is within the control of the architect. True or false? Yeah, I know, it's pretty obvious.
Everyone's saying false, Mike.
Well, that's good. A lot of firms are going to stay in business, I guess. Yeah, obviously, you know, as much as an owner might want you to do that, there's no way you ever can. And this is, again, what you do is you say, okay, this is the best I can do for you and anyone could do for you. But here's some of the things we're going to have to take into consideration. If we encounter them, it might cause the project costs to go up a little bit. So, I mean, always have that in your back pocket because all the work you've done over the years, you've learned everything, every single project you obviously have learned from. And so you can get a pretty good understanding from all of that background when you're sitting down with an owner and he's asking you about what can I expect. You can sort of tell them, hey, you know, you might want to carry this contingency for the following reasons and give some good reasons as what you've encountered on past work that could come up, just so it's there and the funds are available should he encounter them, and it would add to the cost of the project. After considering the fee to be paid and the schedule, a project manager decides that there is insufficient time and profit arising from this project to conduct peer reviews of the construction documents before release. Since the architectural team is senior, more than 20 years experience, he agrees to the fee and schedule and cutting out the peer review. Do you agree with this decision? I see a lot of shaking of heads for the ones I have up here.
Oh.
Yeah, that's a warning that we've always given over the years too, is that, you know, we've seen situations, I've seen some of the, you know, smaller firms where they let people kind of run on their own. I've run into this before, and I've had those firms have had some issues, obviously, because even the most senior person, you know, even with checklists and everything else, there's always a chance you're going to miss something. And you know that if a design issue is caught at the outset while you're doing the work, while you're putting the designs together, that's pretty cheap to fix. But when you get out to the site and you're under construction and now you discover it, that's pretty expensive to fix. So peer review and the usual quality control, quality assurance that goes into the various phases of design, and that's essential. Each step of the way, that's essential and should not be eliminated because of a tight schedule or insufficient funds. You've got to push back for a fee that covers that time and a schedule that covers that time, and reinforce in the owner's mind, this is why it's necessary. You don't want to have a problem, and I certainly don't either. That's why I do this checking, and that's why my results historically have been so good on other projects, because by standing behind my work, I'm doing this on the upfront end to make sure we don't have a problem. Designer signs a subconsultant structural engineer's agreement that limits the structural engineer's liability to the greater of the fee or 100,000. Subject to the limitation of liability, the structural engineer fully accepts the responsibility for loss due to the negligence of the structural engineer, including all consequential losses. The designer has properly transferred its risk to the structural engineer. True or false?
I have false.
Yes, as I harped on earlier, don't accept the limitation of liability from your sub, because the limitation of liability overrides everything else. If you agree to a contractual limitation of liability, and I don't mean you set their insurance limits, you require $1 million of insurance coverage, that's not a limitation of liability. A limitation of liability is a statement in a contract that says the party shall never be responsible for a certain amount of money, in this case, the greater of the fee or 100,000, whichever is greater in this case. That's an absolute statement that says I can screw up in a major way. I can have all the insurance in the world, but you just agreed that I'll never be responsible for more than 100,000 or my fee. That's the risk associated with these things. And you can't bear that risk. A lot of times where you see this come into play is soil engineering agreements. And because traditionally in the industry, they get such a small fee for what they do. And usually it's the owner that retains them. But if the owner's asking you to suddenly include the geotechnical engineer on your team, you really have to sit down with a geotechnical engineer and tell them, I cannot accept your limitation of liability in your contract because I don't have the capabilities of the owner. The owner, if he accepts the limitation, he has to live with that. So he pays more money to fix the problem. But in your case, you're going to get stuck with that liability. And yes, you could turn it over to your insurance company. But if it's a large enough loss, you might find that insurance company doesn't want to keep you as a client, or they want to charge you a lot more money on renewal. And so you don't want to be dealing with that because you didn't cause it. You're hiring a specialist and you want that specialist to step up to the plate. So don't allow subs to have limitations of liability in their agreements. So at that point, I'd open it up for questions. I'll do the stop share.
So, Mike, I don't know if you can see the chat right now, but we did have a question earlier. We have a couple of questions, actually. One was from Peter Kleiner about construction observation, where contractors send frequent video walkthroughs. How do you limit the liability of this extra information where it can be documented in the video that conditions were not observed?
Construction. Where it can be documented in the videos that conditions were not observed. It seems to me that if you're going to be using video walkthroughs and you're being asked to look at it on that basis, you need to be very specific that your observation role or what you think you saw is limited to that video, And if there are things that were not observed, you may even need to actually have to make a statement in writing that you cannot comment on the conditions that were not observed. So, I guess it sounds like you're being able to use now some of the tools that we have available to us here in the, IT world. But associated with that, I might recommend that you speak to an attorney about perhaps putting together a report that would address and say specifically, I reviewed these videos and my observation and professional opinions are based on these videos only. I cannot comment on anything that was not documented in the video as those conditions were not observed. I would be that specific just so that you don't have that situation where they're trying to drag you into having seen everything that you were supposed to see when you didn't.
Michael, a question for you on that. Unless you say in your contract that you're going to accept these videos, why would you want to look at them?
I guess you're right. I mean, that's another thing. I'm kind of anticipating, or I'm jumping ahead here and assuming that everyone agreed at the pre-project planning meeting that we were going to start using videos for the observation. But, again, my position on this would be, this is something pretty significant that I see no reason why the standard approach isn't the right one, and why we wouldn't want to stay with that if at all possible, and push back. And if they're now offering you videos that really were never addressed in the contract, I think you're right. You'd say, we're not looking at these. This is not our role. We're going to be out at the site ourselves. We'll look at what we need to look at, but we're not going to be commenting on these videos.
Just to make it more interesting, you and I are just getting through the pandemic. And for a lot of firms, going to the job site, especially when it's quite remote, is more than a challenge. You may not be able to actually do it. So what we've encountered is we will do a remote review, which is being recorded as it's being done, where the contractor walks the site and using his iPhone or whatever, is showing you what's going on the site so that you can comment and make notes. And that way you have some recorded way of showing the observations. And in this case, I think you'd be okay to use that video because you participated in its creation and you were able to direct the contractor in how to record it.
That's correct, but I also worry a little bit about the technology, using an iPhone versus maybe some, more technical and maybe more expensive camera or even drone that might be able to give you much greater ability to see what you're looking at. I mean, I think if you're going to use this technology, doing it remotely, I think you should probably just maybe kick that one by your attorney, because I want to be sure that the contract addresses the limitations associated with this step that you don't have when you're physically out there. So there are limitations with this no matter what. And I want to be sure the contract addresses that limitation and doesn't make you responsible for something that you couldn't really see because you weren't physically there.
Yeah, I asked that question because I think, in some cases this is something that's done on the project management website. So you can't say, oh no, I didn't look at it. It's basically like, nope, you're given access to it. You have it. That's part of it. Like, and there's sometimes an expectation that that's used, particularly as we're saying during the pandemic or in particular remote sites where access isn't provided. And I think it's just something that we haven't had an issue with it. But certainly during, if there were an issue in terms of discovery, it's part of the legal documentation of the project. And so it comes back to, well, why weren't you looking at the videos and why didn't you see it in the videos? And I think there just needs to be better language around that and how those videos are used. And I think, yes, we need to talk to our attorney and basically figure out what the right language is and how we qualify those.
Yeah, I would agree. Once upon a time, architects were authorized to alert supervisor of any safety concerns. Have rules changed? If someone is in imminent danger, what is protocol now? The rules have not changed. If you see it and recognize that it's unsafe, the best thing you do is warn somebody. If it's not in imminent danger, and this gets back to this pre-project planning meeting, you should have the names, the cell phone numbers of the construction supervisors who are responsible for safety. And so when you're doing an observation and you see something that's unsafe and you recognize it's unsafe, because that's how courts look at it, based on your experience walking sites over your career, if you can see and recognize an unsafe condition, what you do is you contact the person responsible for safety, you tell them about it, you document that you told them about it so he can take action. If it's imminent, there is no harm in warning the people who are in imminent danger, but then immediately going to that supervisor and saying, hey, I just warned your people, here's what I saw. You know, maybe it's an unshored trench that they happen to be in. I warned them they should probably get out of there right away, but I want to let you know this so you can take action on it. And most importantly, if you encounter a situation just like that, document it in your project work file. Because if there's an injury and someone drags you in, as they will, you want to be able to show a court, this is what I did. I didn't accept any responsibility for site safety. My contract doesn't have me do it, but I did the fair and reasonable thing by warning people. And this is what I saw, this is who I warned, and here's the people that were supposed to take care of it. That will get you most likely an early dismissal, because they always will sue you anyways, but we can get early dismissals when we can demonstrate you weren't responsible for what happened in the way of the harm. The other one, can you speak to pros and cons of having sub-consultants contract directly through architect versus owner? This comes down to you. And what is the relationship with the sub? If the sub contracts through you, you control the sub and you have the right to say how they're going to do the work and what you expect of them. If they contract directly with the owner, you stay out of it. The owner has a contract directly with them. And what you might have to do is you might have to find a way to work with that consultant who's doing something separately that might affect your design. So you have to find a way, like you do with the contractor, to work together to make sure everything meshes and that sort of thing. But if you're the party responsible and you're hiring them, and I've heard this a number of times, an owner says, well, I want you to hire this sub, you know, for this reason, whatever. But once they ask you to do that, you take full control over it. Don't think, okay, well, the owner's just doing this for convenience, because I've heard that too many times too, for convenience. There's no such thing as convenience. You got liability. That's not convenient. So you want to be sure you control it and you want them signing your contract. And if they're not going to be happy with that, then they should be directly hired by the owner.
Thanks, Mike. Does anybody else have any other questions?
There's two other things here. Okay, but these look like comments. Site observation by video might happen due to pandemic issues. Okay. And the other one, the camera cannot capture everything a person using the camera is not aware of and they're able to see. Yeah, okay. So those were really back to our comments on the video observation. So I don't see any other questions here. Does anyone have any other questions?
I have a question about quality. We do a lot of hotel work, and the brands have standards, and those standards are incorporated into the documents, and they are part of what we as interior and architectural consultants use in guiding our work. So I had an experience where I walked on the job site and the contractor was doing finishing work, and the environment that he was doing the work in was very dusty. The lighting was poor. The workman's tools were all over the place. And he was starting to apply stain on some very expensive walnut plywood, which was going to be used for some cabinets. And I said to him, how are you going to control the appearance of this material in an environment where you're going to have dust in the stain and in the final varnish? How are you going to get a smooth finish, which is part of the standards that the owner and the owner's brand are expecting? And they hemmed and hawed. And I said, I'm going to be in a difficult position because you're going to ask me to authorize payment for work that's going to be substandard. So did I speak out of school, or was I correct in alerting them that there was a problem that affected the quality of the end product?
I don't think you spoke out of school. I would think, though, usually contracts reference what ability you have over non-conforming work. So would you normally have the right to push back on non-conforming work? I would think you would. The purpose of it being that you want to be sure they meet those standards. But I certainly don't think you talked out of turn on that. And, you know, if you didn't have the ability maybe to actually direct the contractor to change that process, I don't see any harm in just putting it out there and telling the owner, hey, this is what I looked at and saw. You know, do you want to accept that, or do you want to be sure he's going to do something that you know it'll meet the standard? Because if it's affecting the standard that the owner is putting forth, usually the contract says you have to follow that standard. So now if he's doing something that will prevent him from actually meeting that standard, it's better to point it out, I think, and correct it than it would be to, you know, just let it fly and then they're not happy with the work after the fact.
Unfortunately, the owner actually walked into the job site and joined me, and he pointedly asked what was going on, which I told him, and he was delighted that somebody's watching out.
Yeah.
Okay, well, it looks like we're kind of dwindling down here and we've gone a little bit over. But again, I want to thank everybody for being here and for your questions. Our next roundtable will be in March, so stay tuned. If anybody's new and you want to add your email to the chat, please feel free and I'll add you to our email chain. But Mike, thanks again for your presentation. It was very helpful. I think we had a great turnout today and a lot of really informative information. But I wish everyone a really good day, and we will see you soon.
Okay.
Tracy, one last question for Mike. Some of us are kind of inquisitive and we like to follow up on what we learn. And over the years, in terms of studying risk and risk management and so on, I've found some good reading. And I was wondering if you have something you can share with us that we would benefit from reading. For example, many years ago, the textbook of preference for construction law was Justin Sweet, and there may be something more current. So I was wondering if you had something you could share with us.
And that, no, I don't, because we're not attorneys by background. But I would tell you that we have available on our website, which is simply amesgough.com. There's a section in there that has a number of articles on a number of different topics, and you might find some of those useful and helpful. We've done what we call our information alerts and our risk alerts over the years, but they're all on the website. If you got free access to them, you don't have to be a client of Ames and Gough to get that. The insurance companies have those things too, but usually you have to be a client of theirs and have access to their website in that respect. But we freely share that information, and there's other places too. Donovan Hayden is great for that stuff in Massachusetts. And they have a website where that you can get that information. There's also Construction Risk Report. Kent Holland, he has a website that does similar things, and he releases things. I'll send Tracy a link to that afterwards so that she can send it out to the group. But those, Kent's an attorney by background. Donovan Hayden, of course, is a law firm, and they have really good materials, a lot of which I use in putting these presentations together.
Thank you, Mike.
Sure.
Thank you again,
Tracy.
everybody. Mike, if you want to stay on for a little bit, that's fine. If you have any
Sure.
questions for me, again, feel free to email me, but thanks, everybody, again. It was great seeing you.
Thank you.
I'm not sure what happened with Gary, but I think that went really well.
Yeah.
Yeah, I think it went great. If you have any questions for me, or I'll look forward to getting the email on the information that you told Drake about, and then I'll forward it to everybody.
Yeah, it's constructionrisk.com. Very simple, all one word.
Okay,
I'll send it to you though.
that's okay. I got it.
But Kent's got great stuff on there, so.
Okay.
but
All right. Well, thanks again, Mike. I hope you enjoy the rest of your Floridian day down there.
Yeah, okay, well, thank you.
Thank you. Take care.
All right, Tracy, bye.
Bye-bye.